Alex here with part 182 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my omnibus motion to establish a continuing duty to disclose physical residences and medical, dental, and vision benefits information, and to allow the supervision of phone communication, to establish boundaries and procedures for school volunteering, and to establish boundaries and procedures for medical, dental, vision, educational, mental health, and extracurricular appointments. This is the smorgasbord motion that deals with all of the insane, is the only way to characterize it, all of the insane things that my ex started to do after she lost custody. I already mentioned in a number of my previous videos that she was coming to Vegas at least every week, and my understanding was that she stayed in Vegas like half the week, but she didn't live there. She kept her residence in Reno. She did come back and forth. I'm not sure why she did that. In the end, she did stop coming. So whatever reason that was there for her not to move, was still a reason, because wherever it was that she intended to go, she went to. She either stayed in Reno or she went to Hawaii. I think we can talk about this more when we get to the termination of parental rights as to the location that she probably went to. And it's not going to be specific. It's just going to be generally what city. But there was something else that I wanted to mention here as well. I feel like, in a sense, it wasn't just that she was trying to say, I guess, prove to people that she was a great parent. I mean, on the one hand, it could seem that way because it's like, now that she's lost custody, she's trying to do all the things that she thinks she needs to do to get it back. But I think there was another side of that coin, and that was the revenge side. That was the whole, now that you made this happen, now that you're relocated, I'm going to punish you for that. And I'm going to show up at school all the time. I'm going to charge you for every trip that I do back and forth. And I'm going to make it as uncomfortable and as inconvenient as I possibly can for you. I've talked about this before. Sam Vaknin refers to it as their desire to settle open scores with the world. If you want to know my opinion on narcissistic personality disorder, please take a look at that video. If you want to know my opinion on the mental health issues that I had to go through in my case, please watch my video on the topic, evaluating mental health. Both of those videos go into all sorts of details that I'm not going to mention right now because I've already covered it. I guess we can talk about all of the things that she was doing in detail as we go through the document, because if I remember correctly, it's a pretty detailed motion that I filed, so I think most of the story will come out either in the motion itself or in the exhibits that are attached to it. So all of that being said, I always feel like I'm forgetting something, but right now I don't think I am. All that being said, let's go ahead and take a look at what I have filed. Here we have my omnibus motion to establish a continuing duty to disclose. This is what I was talking about earlier in the video. This is the motion that's bundled together a bunch of motions. Start off with a standard introductory paragraph which identifies me to the court as the petitioner, indicates that I am appearing in proper person, which means I don't have an attorney, I'm representing myself. Summary. Okay, so points and authorities, we have the summary. I am identifying myself as natural father. My ex is the natural mother. We share a common child of age 9. I have primary physical custody. My ex has visitation rights. We have joint legal custody for now. I reside in Henderson. My ex resides in Reno. I've repeatedly requested updated information from my ex regarding her physical address, as well as the insurance information. So it looks like that's happening again. She has sporadically made appearances on Las Vegas. I've asked her to coordinate with me at school events as well as various appointments in an effort to avoid the conflict that has occurred in the case to the embarrassment of our child. And my ex has refused to communicate and even intentionally injected conflict into situations. So the first of the several motions is the motion for a continuing duty to disclose physical residences. I go into the procedural history, which involves a multitude of motions trying to get my ex to let me know where she lives. There's so many filings. If you guys want to know more about this nonsense, please watch my video on the topic, right to know where child resides. Next, we have my ex obtaining a fictitious address from the Secretary of State. Next, we have me filing a petition for writ of mandamus. Basically, she asked the government for help, so I sued the government. Then we have my second lawsuit against the government in the Second Judicial District Court. Then we have the Secretary of State's filing a notice that they have canceled her fictitious address. Next, we have the judge pronouncing orally from the bench that he is going to issue a writ of mandamus, commanding the government to turn my ex's address over to me. Next, we have the court filing that writ of mandamus in writing and issuing that writ to the government. We next have the Secretary of State complying with the government's order and turning my ex's address over to me. The problem is that she never updated her address. So the address they gave me was no good because she moved. She probably moved very shortly after losing the case in the Supreme Court. Let's see here. Next, we have my filing of a motion to compel my ex to turn her addresses over to me, or in the alternative for an order to show cause. My ex disclosed her address with a surreply. Okay, I kind of remember that. And the court used the mootness doctrine inappropriately, I might add, to deny my motion. And all that did was cause my ex to hide her address again. I've said it so many times, guys. When you hear these judges make these complaints about having too much work and not enough time, they do this to themselves. If the judge would have entered that order commanding her to continuously disclose that address to me, I wouldn't have had to file this additional motion. So this judge, with his nonsensical order denying and invoking the mootness doctrine, again, inappropriately, he ended up causing me to have to file another motion. So this kind of stuff about the judges complaining, you know what? It's his own fault. He's the one that is doing this to himself. And then, of course, he recused himself, which basically dumped this work on my new judge. But if you want to know more about the proper way to use the mootness doctrine and why so many family court judges abuse their discretion in applying it incorrectly, watch my video on the topic, mootness doctrine. I talk about it, I explain it, and I explain the common pit trap that many family court judges fall into. You can also appeal these pretty easily and win orders reversing because it's pretty logical, concept. You can't apply mootness unless the issue is actually moot. If a judge says an issue is moot and it's not, the Supreme Court or the Court of Appeals will usually overturn it. Next, we have my notification in Our Family Wizard that I provided my address and other pertinent information into the info bank, and my ex refused to respond. So then I asked her pointedly on October 27th, please turn over your physical address, put it into the info bank. And then on November 4th, she responded that she would only disclose her physical address if our son lived with her. Basically, what she was insinuating was that since she lost custody of our son, she no longer had to say where she lived, which is nonsense. And we're going into that now. Legal analysis. This is my own case. I don't know if I've told you guys this before, but there is something surreal about citing your own case in your own case. So I'm citing Falcone v. Secretary of State, which is named after me. If you want to learn more about this, I guess if you watched my Docket series, you probably will already know about it because you will see that I go through the publication from the Supreme Court. And it's titled Falcone v. Secretary of State. So I'm citing my own case here saying that parents who share joint legal custody of a child each have a legal responsibility for their child and for making major decisions regarding the child, including those related to the child's health, education, religious upbringing, etc. To make these decisions requires that both parents be informed regarding the child's circumstances and experiences. Knowing where the child resides allows a parent to have input regarding the environment in which the child is being raised. Duh. Moving on to the next section. I don't know why they have to tell judges obvious things like this, but this is what they had to tell my judge and all the other judges in the state. So now, in Nevada, it's pretty much etched in stone that parents have a right to know where their child resides. Whereas before, I guess for a while, judges kind of knew that, and it's only recently that they suddenly had this idea that you could just live in secret places and not tell your ex. Going into the next section here. By the way, guys, people have told me, hey, Alex, why did your attitude change in the My Docket series? My attitude changed because the circumstances changed. In the beginning of the My Docket series, a lot of what the judge was doing made sense, and a lot of what I was doing made sense that it was wrong. And so I went through the beginning portions of the My Docket series saying, hey, these things that I'm filing aren't really right. This is the wrong approach, etc. The judge is helping me out here. It's good. This is constructive. This is the right approach. That's why I had a different attitude in the beginning of the My Docket series. Eventually, the judge started to screw up a lot. And then the new judge took over, and then she started to screw up. And so as the judges started to screw the case up, my attitude started to get like, the attitude that I have now. So my mood and my approach and my attitude as I go through the My Docket series reflects the status of the case. When the judge is doing his job correctly, when the court is doing its job in the way that it's supposed to be done, of course I'm not going to be angry at the system. I'm going through these documents and I'm evaluating what the system is doing, and it makes sense to me, at least in some way. Once the system starts to get inane and nonsensical, I start to get pissed off, as anybody would. Anybody who has kids and sees that the court system is facilitating the abuse and neglect that's being inflicted on their children is going to get pissed off. They're going to get mad. And so I've decided not to hide this. When I go through these documents and I see something that makes no sense, I call the court out. I call the judge out. It doesn't make any sense to me let me clarify this a little bit. Let me say this in a different way. When the system doesn't know what's going on, it's not the system's fault. But once you notify the system, once you tell the government, once you tell the judge, this is a problem, and then they having the knowledge that they having the information that they have, refuse to take action, it's at that point in time that the blame shifts from your ex to the government. And the reason why, at least in my case, is because my ex, I sincerely believe, had mental health issues. I don't think that she understood what she was doing. The judge knows better. And so I do put a lot of the blame on the court and the judges because they know better. They're supposed to be the adult here, and they're not doing what they're supposed to do. So I call them out on that. And that's why I get, this annoyed sort of attitude, because I am legitimately very annoyed to see this happening in this case. And of course, if this is happening in my case, it's happening in a bunch of people's cases. I'm not just an anomaly here. Otherwise, I wouldn't have 5,000 plus subscriptions. If it was just me and nobody else and everybody else was having a great time in family court, I wouldn't have a swarm of people coming to the website and joining my membership. Anyway, let's move on. While the court's existing orders clearly define joint legal custody and even state that parties have a right to know where their child resides, there is no provision that imposes upon parties a continuing order to disclose. And I talk about this in Davis v. Owalafu. Some of my subscribers have noticed that this case is actually a really remarkable case, because it says that a judge has to make orders that are enforceable. It's not enough for a judge to just say you have rights. The judge has to make it known not only that you have rights, but that those rights are enforceable. And if the court doesn't do that, it's an abuse of discretion and it is reversible error. And that's what this case talks about. I love this case. I guess I could read it here. An order awarding a party a limited right of custody to a child must define that right with sufficient particularity to ensure that the rights of the parties can be properly enforced. If it's not enforceable, it's not good enough. Again, duh. Moving on to the next section. My ex has been admonished by the court for the same issue before. The court said, I guess he admonished her and he gave her like a speech or something like that she needed to read. She didn't care, and she just kept on doing what she was doing over and over again. And that's what I'm saying in this paragraph here, is that the judge just keeps admonishing her and she could care less. If only more judges understood the language that these types of people understand. They understand being fined a little bit. They understand being thrown in a cell a whole lot more. I talk about this terrible conclusion that we end up having to reach in the video control. Going into the next section, despite Davis v. Owalafu, despite the fact that it controls, I also address this court's previous application of the mootness doctrine. So the reason I'm talking about the mootness doctrine here is because my previous judge screwed up its application so many times I lost count. And so I am preemptively here trying to tell the new judge, please don't do what the other judge did a bunch of times. Again, guys, mootness, it's a very common area where family court judges screw up. Please watch my video on the topic mootness doctrine. So I'm just explaining to this judge how it works in the hopes, crossing my fingers, that she won't screw up also, which I don't think she does. Going into the next section here, contempt. We've seen the contempt citations probably 50 times by now. If you want to know more about how this works, please watch my video on the topic contempt of court. I'm citing all the same laws that I've been citing over and over again in this case. Going into the next section, motion for a continuing duty to disclose medical, dental, and vision benefits cards. Same problem. The previous judge ordered my ex to turn the cards over. She turned the cards over, and then she stopped. Why? Because he didn't tell her to keep doing it. So I'm trying to ask for a continuing order to turn the cards over. That's what I'm going into. First paragraph is that I have established the child's dental provider. The motion practice described in section 2A seeks to compel my ex to disclose the medical, dental, vision benefits continuously. That's all I'm asking here as well. Going into the next section, I think I might as well just move on to the next section because, oh no, I forgot. This also goes into her, okay, so this goes into the history of her failure to turn over these cards. So if you want to learn more about this, you can watch my video on the topic, denial of access to medical care, because this is something that she did in the case a bunch of times. The judge did hardly anything, and here we are, again, with me filing another motion. Moving into the next section. I requested my ex to post her medical, dental, vision information cards into the info bank of our family wizard. She said that I needed to stand by. Next we have that I reminded her, I'm still waiting for that information. I reminded her again on October 21st that I am still waiting for that information. And then on November 4th, we're going to go into all these emails, by the way, guys, when we get to the end of this document. And then on November 4th, I claimed that she finally changed her insurance providers and the relevant information was going to be mailed to her. To date, she still hasn't posted anything. We have legal analysis, child's medical, dental, physical, blah, 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 providers. Child's dental provider even went so far as to contact my ex directly to ask for the information. My ex's failure to disclose the insurance information unnecessarily delays and creates uncertainty in the insurance process because insurance providers have specific agreements as to how they provide coverage when a patient has multiple coverage plans. The Supreme Court has stated a bunch of times that the best interest of the child control on this issue. The medical, vision, dental benefits disclosed by my ex in 2009 was effective in shielding her from contempt when I filed a motion in April 22nd, 2013. And it would effectively shield her from contempt again because, as the judge stated in that previous motion for order to show cause, she's not in violation of a court's order because she complied with that order years ago. She doesn't have to comply with that order going forward. She only has to comply with that order years ago. So when the information changes, she doesn't have to say anything, at least not according to contempt of court principles. Things get a little bit more complicated when we look at legal custody principles, and I will end up getting sole legal custody. It just takes forever. Going into the next section here, despite the primary point that Davis v. Awolofu controls on the issue, I also address mootness doctrine again. Again, guys, the reason I keep regurgitating this case law is because I really just want to rub the judge's face in it because they constantly make mistakes on mootness, and I want them to stop making mistakes on mootness. Moving into the next section here, contempt again, for the 50th time, cited contempt principles. Same exact laws, guys. If you've seen this series, you would have seen these laws already a bunch of times. Motion for order allowing supervision of phone communication. Okay, so the court ordered daily phone communication from my ex. I facilitated phone contact with my ex. She liked to speak with the child in private. There was one point where she told him to go to the closet and close the door because she wanted to talk to him in the closet in private. Next section here, I enrolled him in mental health counseling with a therapist. The therapist said, hey, your son's not responding to any questions. On September 6, 2015, after the child's daily telephonic communication with my ex, the child notified me that my ex had instructed him to answer the mental health provider's questions with a code word. I then immediately notified counsel and notified my ex that I would be supervising phone contact from then on, and my ex failed to respond to or read the message. Legal analysis. This is going to talk about the best interest of the child and how what she's doing is wrong because it's causing the child to shut down communication with the mental health providers. This is very common, guys, in high conflict cases. If a judge does not know this, they should be fired. This is so obvious. For a judge to not know that high conflict exes will coach the child, it's like a judge saying 2 + 2 is 7. You just have to give them this blank stare and be like, what are you talking about? Get off the bench. You don't know what you're doing. Same thing here, guys. Judges should know better. The judge should know that this is an extraordinarily common thing in a high conflict child custody case. This is not rare. This is not even uncommon. If it's a high conflict case, it's happening all the time. And so they need to catch up to this. If you want to know more about why so many judges don't understand this, please watch my video on the topic, high conflict incompetence. Going into the next section, motion to establish boundaries and procedures regarding school volunteering. Same problem with school volunteering, but I guess we can go through the factual background. So August 22nd, my ex is letting me know that she's going to volunteer at Lamping Elementary so that I could. Oh, so I asked my ex to let me know when she was going to volunteer so I could give her space. Basically, I was saying, hey, if you're going to volunteer, I'm not going to go. That way you can just be you. On the same date, my ex responded that she would instead request that I inform her as to when I intended to volunteer so that I could let her, so that she could let me know which of those days she would be attending on. September 3rd, I complied with her request. So I complied. I'm not being a jerk. I'm like, okay, here's the days that I'm going to go. On September 16th, my ex deliberately appeared. She was like, oh, that's where you're going to be? All right, I'm going too. Let's create some conflict. That was on purpose. Again, guys, judges should know this. If judges don't know this, they should be fired. This is very, very common in high conflict child custody cases. Again, please watch my video on the topic, high conflict incompetence. It goes into why judges don't get it. Some of the judges are starting to pick up on it, but a lot of the older ones don't understand it. On October 11th, 2015, I notified my ex that there were a multitude of messages that she had not read yet. On October 13th, I recalled the September 16 incident, and I sent my ex a message telling her to clearly state whether or not you're going to show up at the child's Halloween party. My ex failed to respond to or even read this message, so on October 21st, I notified my ex that I was attending or rescinding the letter submitted to the principal allowing her to appear at my custodial time, and the message brought to my ex's attention the total collapse of communication regarding volunteering, and I asked my ex to propose some kind of plan going forward. She failed to read the message. By the way, guys, she did eventually show up on that day, and the principal said, you can't come on the campus, and she got so pissed off. And it was a setup. She wanted that to happen. She wanted to be banned from going to campus. And she knew that if she would comply with my requests, it wouldn't have happened. In fact, when she gave me a counter request, I think she was expecting me to say no. So she gives me a counter request, and I'm like, okay, I'll comply. I show up, and then she's there. Because that's what she wants. She's like, oh, that's when you're going to go to school. I'm going to go too. And I'm going to cause issues. And then after that, I say, you know what? You need to let me know. I'm putting my foot down. She doesn't let me know anything. So I rescind her access. And then that's when she goes, ballistic and makes a big deal out of it. I don't think it ends up going anywhere because her lawyer will end up abandoning her very soon. But just letting you guys know that this was an engineered outcome. This was the road that she was traveling to get to a very specific conclusion. And for her to get banned from going to school, she had to commit a certain series of misconduct for that to happen. And so she was willing to do that to make it happen. She did not want this to work out. She did not. I mean, if you look at my communications, we're about to go into the emails, you'll see that she's basically getting access to the school anytime she wants, and I won't go. I'm telling her, hey, if you're going, I won't go. So if she really wanted to go to the school, all she had to do was say, hey, I'm going to go on these particular days. And then I'd be like, okay, fine, I'm not going. But that's not what she wanted. She wanted conflict. So she needed me to not know when she was going to go so she could just drop in. Legal analysis. So I recognized and encouraged, or the court recognized and encouraged my utilization of the civil process. Quote, the court also notes that based on the substance of and the number of pleadings and papers on file, the court is satisfied that I will continue to utilize the court asking for permission when needed rather than take unilateral action, unquote. And I'm using this against the court to make it clear that, hey, you noticed that I was using the process properly, and I am using the process properly again right now. The reason I put that in there is because oftentimes the judges have amnesia, and they'll immediately fall back on, oh, you must be vexatious because you filed too many papers. If you want to learn more about why judges have this approach, please watch my video on the topic, self-representation bias. Let's see here. I now am requesting an order from this court affirming the delegation of parental rights regarding volunteering, and it's basically me asking the court to separate apart our parental rights with regards to going to the school. Motion to establish boundaries and procedures regarding medical, dental, vision. Same thing, guys, but this is for medical, dental, vision appointments, all that stuff. So let's go into the factual background. We appeared at our son's first mental health counseling appointment with the therapist there. I explained to my ex that the sessions were for our son and that we were not, that our involvement in those sessions would not be typical. Basically, I was telling her it's weird for us to go in there. It should just be our son only. My ex insisted on appearing, and when the therapist appeared to receive the child, my ex made a scene in front of the waiting room, pushing a cell phone into his hand and informing him that he could call her by that cell phone if at any time during the session he was uncomfortable with the therapist. This served to fill our child with anxiety and caused our child to be less open and forthright with the therapist. The exchanges continued for a number of subsequent appointments where my ex made spontaneous appearances and often monopolized the entire time allotment set for the child's sessions. So yeah, she would basically just use up the entire session talking to the therapist so that he wouldn't get any questions asked of him. On October 28th, 2015, she appeared at the child's medical appointment. I notified her that I intended to caucus with Jennifer Ralph, the child's physician, and my ex argued with me in front of a packed waiting room and refused to accept my suggestion, demanding that we both be present at all times. I thought I was scary. Didn't she say like I was a bad person? Wouldn't she want me to not be in that room with her? That's odd. That's a very odd thing when you tell your ex, hey, we're going to meet separately with the doctor, and she says, this horrible, horrible, dangerous, mean person, I'm insisting that he be with me in the room. I want that. That's very strange to me. I thought she was, dealing with an abuser. I don't know what's going on now. So anyway, if you guys can't tell, that's sarcasm. But let's go into the next section here. Legal analysis. The court encouraged and recognized. So once again, I'm copy pasting this statement here where I'm utilizing the civil process. I'm asking the court to delegate parental rights regarding the medical, vision, dental, educational, curricular, blah, blah, blah. What I'm basically going to ask the court to do is to order that she is banned from going to any of these appointments, and I am banned from going to the vision appointment. Don't worry, I'll have access to the vision appointment very soon when she fails to take him to the vision appointment, but that's going to be dealt with in a separate motion. So hang in there for that. Mediation. A bunch of times you guys have seen me copy paste this. I basically use a bunch of court rules to let this judge know that mediation is futile, a waste of time, and a waste of money. If you want to learn more about how I do this, please watch my video on the topic mediation and settlement. We are lucky to be in I was lucky at the time to be in a district that had a local rule that explained to judges that there are certain circumstances where mediation is not appropriate and you should not be sending parents to mediation in those types of cases. My case fell right into that category. Hearing. I am not requesting a hearing on any of these matters. All of the relief requested is reciprocal in nature, solution-oriented, and is substantiated by findings. I don't know if this is really appropriate. I think if my ex filed an opposition and she opposed certain factual allegations, I think a hearing would have probably been required. And the reason why is because the court can't take evidence unless an evidentiary hearing is held. So it is possible that in some situations, depending on what she said, like if she just had legal objections, that would be one thing. But if she was denying the factual allegations, that might have forced a hearing on this issue. I think it probably would have. But anyway, I can't remember going to a hearing on this issue. In fact, I know for sure I didn't. And I'm not even sure if she really opposed it. We're going to have to wait and see when we get to that opposition. Conclusion. Therefore, I hereby request, and then I go through the list of all the things that I already asked for in the motion. Verification. I am swearing under penalty of perjury that all of the facts alleged in this document are true and correct. Rule 5, Certificate of Service. I'm indicating that this document was mailed to my ex's attorney. Motion opposition notice. Based on the marks placed in these checkboxes, I do not have to pay a $25 filing fee. List of exhibits. We have 15 different exhibits, and they are all Family Wizard messages. Exhibit 1. So I am telling my ex, adding my number and my ex's address to the book in the Wizard, so in the future it will always be available to her. You may want to add your info as well. Exhibit 2. Me, again, to my ex, just an FYI, our son mentioned going to San Diego last weekend. Regardless of whether this actually happened or he's confused, I'm taking the opportunity to ask you to put your grandparents' information into the info bank under caretakers. That's how you use our Family Wizard. You put information into it. Exhibit 3. My ex replies. If she leaves Army with somebody, she'll let me know ahead of time. She has no reason to leave him as she doesn't have a job and she can spend 100% of time with him. Oh, yeah, so we went through this already. Exhibit 4. If there is no caretaker, then there's no person to list, but the order still requires an address when taking him out of town. It's good for both parents to know just in case. This is obvious. She's just playing dumb. She's acting like she doesn't know what she's supposed to do. She's acting like she doesn't understand the court's order. And so here I am trying to clarify it for her so that I can use this message later on when I file a motion like I did just now. Exhibit 5. I am now telling my ex to load the insurance information into the info bank. Exhibit 6. My ex is responding to me. You already have all the insurance info that she can see that I have it in the address book. She's going to be signing up for new coverage, so by September sometime, she'll have the new insurance. Next section. From me to my ex. Please advise on the return of those 3 money orders. Also, the ledger has been updated to reflect the new arrears. Still need insurance info. Exhibit 8. from me to my ex. Your campus access has been rescinded. And here I explain that I sent a letter to the principal rescinding her access to the campus. Volunteering is not supposed to be an opportunity to inject conflict into his life. And then I explain, I memorialize the messages that I communicated to her to try to avoid conflict. And then I state that I could understand that this was a series of isolated incidents, but it is a growing theme. And then I explain even more emails that I sent to her with regards to that. Communicating at this point is absolutely necessary. The therapist thinks that it's best that we alternate when we exercise our parental rights with our son, more so than the conflict between us. It raises his anxiety as a child, and it really did. When our son would see the conflict, he would get anxious and he would be embarrassed. He would feel like the kid with weird parents. It was absolutely embarrassing and humiliating for him. We would stand out to all of these people as the weird family. I mean, I can't even say that couldn't get along. We just looked like a weird family to people. It was so bad. And the judges do not take this seriously. It's just infuriating to me because they act like they care about the best interest of the child, and yet the child is literally humiliated in front of his third-party caregivers. This is just one of the other things that the courts are to blame for. In this particular case, once the judge has the information and doesn't take action, it's the judge's fault. Going into Exhibit 9, the therapist has been with our son twice so far, and everything is going well, except that she wants him to answer more questions. Initially, I thought he was just warming up to her, but he mentioned to me today that he was, told to answer her questions with blah. Furthermore, his exact words were that it is the code word. So he knows it's a code word. He's saying it to the therapist rather than answer her questions. The purpose of a therapist is to put him in touch with his inner feelings and to help him develop his own identity. Encouraging him to not answer questions with a code word is extremely counterproductive and even harmful. Again, guys, I already know that she knows this. She doesn't care, but I need to say this because the judge is ignorant. These communications are not for my ex. She's not learning anything here. She doesn't care. She knows she's inflicting damage and it's fine with her. This is for the judge to get them to understand. If you don't say this stuff and then you show up in court and say, well, the reason I didn't say it is because my ex wouldn't listen, then your ex is going to say, oh, that's not true. I would have listened. And now the judge doesn't know who to believe. It's better to just say it, shove it in the judge's face, and get some kind of relief. Please watch my video on the topic communication. I explain why you have to take this approach with family court judges that just don't understand. Exhibit 10. Exhibit 10 is from me to my ex. The details regarding the letter you asked me to submit to the principal. The teacher was advised that the principal would be giving her updates. In particular, let us know when you're going to volunteer at the school, because when you're there, it is better that Brittany and I just give you space rather than show up. Exhibit 11 from my ex to me. Why don't you let me know when you are going to be there? Put it on the calendar, and then I'll let you know when there are conflicts in schedule. She lied. So I put it in the calendar, and then she just shows up on purpose. She doesn't let me know anything. Going into the next section here, Exhibit 12. We posted some volunteering on the calendar. If you're interested in appearing on those days, let us know. Okay, so once again, I don't know how many times I can say it. Let us know when you're going to go so we don't go. Going into the next section, Exhibit 13. Our son has indicated, so this is from me to my ex, that he would prefer to join a swim team. This just goes into how the swim team is going to work. This is also listing out the messages that my ex has not read yet. One of the things that I love about our family wizard is it keeps track on when your ex is not even opening messages. Exhibit 14. From me to my ex, please let us know if you're going to be at the Halloween party, or if you will not be there. If you don't inform us in a timely manner, I'm going to arrange to be there. We don't have a written order yet, but we can honor your Halloween visit based on the proposed order that is currently pending. Oh yeah, there's me being nice again. You still have 14 unread messages, so she's still not reading stuff. Exhibit 15. My ex to me. She says, I have a right to be at his medical appointments. I will be fine in the waiting room where you are waiting. I'm already here in the parking lot. So she's just saying I have a right to be there. Not for long, because the court's going to enter an order saying not that. And that's it for this document. Next, we have the case appeals statement. This is a document that I've gone over a number of times. As I mentioned, I was pretty sure that the clerk of the district court was going to prepare it. The reason that the clerk prepared this for me is because the rules say so. The rules of appellate procedure in Nevada require the clerk of the lower court to prepare the case appeal statement for any proper person litigants. If you have an attorney, then the attorney will file the case appeal statement. But since I didn't have one, the clerk of the court was required to do it. Other states may be different. If you want to learn more about this, please watch my video on the topic filing an appeal. I talk about it in detail in that video. Next. Certificate of clerk and transmittal, notice of appeal. This is just communication from one court to another. The district court clerk is communicating to the Supreme Court clerk that a notice of appeal was filed in this case, and she is transmitting that notice of appeal to the Supreme Court. Notice of disassociation of counsel. This was filed by my ex's attorney. He is indicating that he is disassociating as my ex's attorney of record in the appeal only. All papers, pleadings, and correspondence in the appeal should be served directly upon my ex. He's basically saying, I am not representing her on this appeal. I am only representing her in this case. And that won't be for very much longer. He will withdraw from this case as well. Affirmation. Pursuant to the law, this document doesn't contain a social security number. Certificate of service indicating under Rule 5 that this document has been mailed to me. Next we have amended certificate of service. This is a correction to his prior certificate of service. He is telling the court and me that my ex needs to be served at this P.O. box, I guess. And I think that's it. Oh, wait, another certificate of service indicating that this document was mailed to my ex. Oh, so he must have just forgot to serve her with that document as well. That's probably what's going on here. Going into the aftermath, I filed looks like just one document. Is that right? Yeah, one document. But that was a free filing, so I incurred $0 in costs. My ex's attorney filed looks like just 2 documents. So 2 documents, and those were both free filings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have had to put some time into some of this stuff. I feel like the notice of disassociation is just going to be one of those form documents that he probably just had a secretary fill in a bunch of blanks. Same thing with the amended certificate of service. Probably both of those documents was 15 minutes. The case appeal statement, I doubt he even cared about. The certificate of the clerk, same thing. So we're still at 15 minutes. The omnibus motion is a ginormous document. He would have had to read that. It's very detailed. He would have also had to go through all of those email our family wizard communications, and he would have had to communicate with my ex on that issue as well. With such a gigantic document, it's very hard for me to think that he spent any less than maybe 45 minutes on that document. And that's going to round us up to an hour. At the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.